Hello viewers, today I am going to take Company Law Lesson 1. Lesson 1 deals with company administration. In this lesson, I am going to discuss evolution of company law, that is history of English company law, history of Indian company law, and administration of the Companies Act by the central government and judicial bodies and quasi-judicial bodies discussed under the Act. Broadly, laws may be classified into three kinds: pre-law, public law, and private law. Pre-law means repealed laws and which are not in force today. Public law means which defines the rights, duties, and powers of the state, and it also determines the relationship between the state and its subjects. Private law means which determines the relationship between the subjects inter se, that is between two individuals of the country. Private law is again classified into substantive law and procedural law. Procedural law is also called adjectival law. Substantive law is that law which defines the rights, duties, and obligations of the individuals. Law of contracts and Indian Penal Code, etc., are examples for substantive law. Procedural law is that law which prescribes the procedure to determine the remedies. Civil Procedure Code, Criminal Procedure Code, and Evidence Act are examples for procedural law. The subject, company law, is private law. It is both substantive law and procedural law. It is codified law. It is both civil laws and criminal laws. In India, Constitution, which came into force on 26th January 1950, is supreme, and all laws and government actions are subordinate to our Indian Constitution. If it is found that any act, regulation, rule, notification, or guideline or government order is not according to the Constitution, it is unlawful and void. One should know that act is passed in the body politic, regulations are framed by the statutory bodies, and rules are framed by the executive, that is government authorities. All regulations and rules must be subordinate to the act and should not be contrary to the act. To get enforcement in the court of law, these rules and regulations must be laid before Parliament when it is in session for 60 days. Rules and regulations come under delegated legislation. In Union List, in List 1, Entry 43, Entry 44, Entry 48 deal with corporate laws. Now we will discuss the difference between company law and corporate law. Company law consists of only Companies Act 2013, whereas corporate law consists of Companies Act, SEBI Act 1992, Securities Contract Regulation Act 1956, Foreign Exchange Management Act 2000, Competition Law 2002, and all allied laws come under corporate laws. In England, in the year 1844, for the first time, Joint Stock Companies Act was passed, and it provided for registration of all new companies with more than 25 members or with shares transferable without the consent of all members. It created the office of the Registrar of Companies. In the year 1855, the Limited Liability Act was passed, providing for limited liability. The Act was repealed by the Joint Stock Companies Act 1856. It introduced Memorandum of Association, Articles of Association, and limited liability concept. Subsequently, new acts were passed in the year 1862, 1908, 1929. Further, English Companies Act 1948 was passed, and in turn it was repealed by the English Companies Act 1985. English Companies Act 1985 in turn was repealed by the English Companies Act 2006, and it came into force from the year 2009. In India, In the year 1850, an Act for registration of joint stock companies was passed in line with the English Companies Act 1844. Under the 1850 Act, the Supreme Courts of Calcutta, Bombay and Madras were the registering authorities of the companies. The Indian Companies Act 1956 closely followed the English Companies Act 1948, which was founded on the report of the Cohen Committee. On the other hand, the Indian Companies Act 1956 was founded on the report of Baba Committee. The Indian Companies Act 2013 was passed on 30th August 2013, and many of the sections of the Act can be compared with UK Companies Act 2009. Overall administration of the Companies Act is vested in the central government. It is administering the Act through the Ministry of Corporate Affairs. Secretary, Ministry of Corporate Affairs, is responsible for overall administration of the Act. India is divided into 7 regions. 7 regional directors are in charge of the respective regions. Each region is comprising of number of states and union territories. Each state in the country is controlled by the Registrar of Companies. Regional directors supervise the working of the Registrar of Companies and official liquidators in their region. The regions are Eastern Region, Kolkata; Northern Region, Noida; Northwestern Region, Ahmedabad; Northeastern Region, Shillong; Southern Region, Chennai; Western Region, Mumbai; Southeastern Region, Hyderabad. Listed companies are controlled by Securities Exchange Board of India, and it is attached to Ministry of Finance, Government of India. Official liquidators are officers appointed by the central government under section 359 of the Companies Act 2013 and are attached to various high courts, and their duty is to conduct and supervise the winding up proceedings of the company. Now we will discuss about company courts. These company courts are discussed under section 2 subsection 29 of the Companies Act. Under the Companies Act 2013, as far as civil matters are concerned, court means the High Court having jurisdiction in relation to the place at which the registered office of the company concerned is situated, except to the extent to which any jurisdiction has conferred on any district court or district courts subordinate to the High Court under subclass 2. The district court, in cases where the central government has by notification empowered any district court to exercise all or any of the jurisdiction conferred upon the High Court within the scope of its jurisdictions in respect of a company whose registered office is situated in the district. As far as criminal matters are concerned, the Sessions Court having jurisdiction to try any offence under the Act or under any previous company law. Now we will discuss about National Company Law Tribunal. It is discussed under section 408 of the Companies Act 2013. The central government has to establish a tribunal called National Company Law Tribunal. It has to consist of a president and such number of judicial and technical members as may be deemed necessary. They are to exercise and discharge such powers and functions as may be conferred on the tribunal by the Act. According to section 409 of the Companies Act, the president has to be a person who is or has been a judge of a high court for 5 years. A judicial member has to fulfill the qualification of a high court judge or the district judge for 5 years or an advocate with 10 years standing at the bar. A technical member has to fulfill any of the following qualifications: a member for 15 years of Indian corporate law service, Indian legal service, out of which at least 3 years to be in the pay scale of Joint Secretary to the Government of India or equivalent or above, or Chartered Accountant in practice for 15 years, or Cost Accountant in practice for 15 years, or Company Secretary in practice for 15 years, or a person of proven ability, integrity, having special knowledge and experience of 15 years in law, industrial finance, industrial management or administration, industrial reconstruction, investment, accountancy, labor matters or such other disciplines related to management, conduct of affairs, revival, rehabilitation and winding up of companies, or 5 years standing as presiding officer of a labor court, tribunal or national tribunal constituted under the Industrial Disputes Act 1947. Now we will discuss the constitution of National Company Law Appellate Tribunal. It is discussed under section 410 of the Companies Act. The central government has to establish a National Company Law Tribunal. It has to consist of a chairperson, judicial and technical persons not exceeding 11. It has to hear the appeals against the orders of National Company Law Tribunal. The chairperson has to be the judge of a Supreme Court or Chief Justice of a High Court. A judicial member has to be a person who is a sitting or retired judge of a High Court or judicial member of tribunal for 5 years. A technical member has to possess the same qualification as is stated in the constitution of the tribunal. Now we will discuss about the selection of members and term of office. This concept is discussed under section 412 and 413 of the Companies Act. The president of the tribunal and chairperson and judicial members of the appellate tribunal have to be appointed with the consultation of the Chief Justice of India. The members of the appellate tribunal have to be appointed on the recommendation of a selection committee consisting of Chief Justice of India or his nominee, chairperson, senior judge of the Supreme Court or Chief Justice of a High Court, member, secretary, Ministry of Corporate Affairs, secretary, Ministry of Law, secretary, Ministry of Finance. The president and every member of the tribunal are to hold office for a term of 5 years from the date on which he enters upon his office. He shall be eligible for reappointment for another term of 5 years. The age of retirement of the members 65 years. The age of retirement of the president is 67 years. 50 years is the eligible age of appointment. They are also eligible for reappointment. Chairperson holds the office up to 70 years and members up to 67 years. Now we will discuss about appeals from National Company Law Appellate Tribunal. That is discussed under section 423 of the Companies Act. Any person aggrieved of an order of the National Company Law Appellate Tribunal may file an appeal to the Supreme Court within 60 days from the date of receipt of the order. An appeal lies on a question of law arising out of the order. The period may be extended by another set of 60 days on sufficient cause. Now we will discuss about special court constituted under Companies Act. This is discussed under section 435 of the Companies Act. The central government may, for the purpose of providing speedy trial of offences under the Act, establish or designate as many special courts as may be necessary. Such court has to consist of a single judge. He has to be appointed by the central government with the concurrence of the High Court Chief Justice, within whose jurisdiction the judge to be appointed would be working. The qualification for appointment is holding the office of a sessions judge or additional sessions judge. Now we will discuss about appointment of company prosecutors. This is discussed under section 443 of the Companies Act 2013. The central government has to appoint company prosecutors for conduct of prosecutions arising out of the Act. Persons so appointed are to have all the powers and privileges conferred by the code on public prosecutors appointed under section 24 Criminal Procedure Code 1973. Now we will discuss about mediation and conciliation panels. This topic is discussed under section 442 of the Companies Act. The central government has to maintain a panel of experts to be called as the mediation and conciliation panel. It has to consist of prescribed number of experts and of prescribed qualifications. Its function is to bring about mediation between parties during pendency of any proceeding before the central government or tribunals. Any party to the proceeding may apply to the central government or tribunal in the prescribed form on payment of prescribed fee for referring the matter to the panel. The matter may then be referred to one or more experts from the panel. The central government is empowered under section 458 of the Act to delegate any of its functions or powers to such authority or officers as may be specified in the notification. The delegation can be subject to conditions, restrictions and limitations as may be specified in the notification. Now we will discuss about Company Law Board. It is discussed under section 10E of the Companies Act 1956. The Amendment Act of 1988 established an independent Company Law Board to exercise the judicial and quasi-judicial functions hitherto exercised by the courts or the central government. The board was subject to the control of the central government. The central government was empowered to appoint chairman and members of the board and to frame rules to prescribe qualifications and experience of the members. The board may regulate its own procedure and is to be guided by the principles of natural justice. The CLB can have a maximum strength of 9 members. There is no stipulation for the minimum number which the CLB must have. The board is empowered to form benches for the exercise of powers and discharge of functions of the board. The board may, by an order, specify the jurisdiction and place of sitting of each such bench. The board has principal bench at New Delhi. Besides, there are 4 regional benches working at New Delhi, Mumbai, Kolkata and Chennai. The principal bench constituted by the board is vested with the powers of civil court while trying a suit under the Code of Civil Procedure 1908. It may be noted that although the board exercises the powers of the court in respect of some matters under CPC, it is not a court. An order made by the board may be enforced the same manner as if it was a decree made by a civil court in a suit before it, and the CLB may send it for the execution to the court within the local limits of whose jurisdiction A, the registered office of the company is situated in case the order is against the company, or the person concerned voluntarily resides or carries on business in case the order is against any such person. In exercise of its powers and discharge of its functions, the CLB shall be guided by the principles of natural justice. The appeal lies to the High Court within 60 days from the date of communication of the order to CLB. The limitation period can be further extended up to 60 days if the court is satisfied that the appellant was prevented by sufficient cause from filing the appeal. An appeal lies to High Court under this section on any question of law arising from any decision or order of the Company Law Board. A finding of fact recorded by the CLB is final and is therefore not appealable. The jurisdiction of the High Court in appeal is expressly confined to the determination of any question of law only. It follows that a finding of fact cannot be reversed by the High Court. Section 10F provides for dissolution of the Company Law Board consequent upon setting up of the National Company Law Tribunal, and once it is constituted, all matters pending before Company Law Board shall be transferred to the newly constituted tribunal for disposal. Now we will discuss another new authority constituted under the Act by Companies Act 2013, that is called Establishment of Serious Fraud Investigation Office. This is discussed under section 211 of the Companies Act 2013. The central government has to establish an office called Serious Fraud Investigation Office to investigate frauds relating to companies. The office is to be headed by the director. It has to consist of the prescribed number of experts from the following fields to be appointed by the central government from among the persons of ability, integrity and experience in banking, corporate affairs, taxation, forensic audit, capital market, information technology, law, such other fields as may be prescribed. The central government has to appoint by notification a director of the office who has to be an officer not below the rank of a joint secretary to the Government of India, having knowledge and experience in dealing with matters relating to corporate affairs. According to section 212 of the Companies Act 2013, where the central government is of the opinion that it is necessary for Serious Fraud Investigation Office to investigate into the affairs of a company on a receipt of a report of the registrar or inspector under section 208 or on intimation of a special resolution passed by the company to the effect that its affairs are required to be investigated or in public interest or on request from any department of the central government or state government. The central government may assign the investigation to Serious Fraud Investigation Office. Its director may depute such a number of inspectors as he may consider necessary for the purpose. The report has to be submitted within a period specified in the order. The officer designated for investigation is to have the powers of an inspector under section 217 of the Act. Now we will discuss about powers of SEBI. This is discussed under section 24 of the Companies Act 2013. The central government has been given the power to set up Securities Exchange Board of India by passing a special act in the Parliament called Securities Exchange Board of India Act 1992. SEBI has been established as a body corporate having perpetual succession and a common seal. It has powers to acquire, hold and dispose of property, both movable and immovable, to contract and to sue and be sued. The head office of SEBI is situated at Mumbai. Now we will discuss the constitution of SEBI. The SEBI shall consist of the following members: a chairman to be appointed by the central government, 2 members from amongst the officials of the ministry of the central government dealing with finance and administration of the Companies Act 1956 to be nominated by the central government, 1 member from amongst the officials of the Reserve Bank of India, 5 other members of whom at least 3 shall be whole-time members to be appointed by the central government. The general superintendence, direction and management of the affairs of the SEBI shall vest in a board of members which may exercise all powers and do all acts and things which may be exercised or done SEBI. Now we will discuss the functions of SEBI. These functions of SEBI are discussed under section 11 of Securities Exchange Board of India Act 1992. It shall be the duty of SEBI to protect the interest of investors in securities and to promote the development of and to regulate the securities market by such measures as it thinks fit. The powers and functions of SEBI are discussed in section 11 subsection 2 of the Act. Section 55A of the Companies Act 1956 was inserted by the Companies Amendment Act 2000 to provide that specified provisions of 1956 Act in case of listed companies and public companies which intend to get their securities listed will be administered by SEBI. In respect of other companies, the said provisions will continue to be governed and administered by the central government through the Ministry of Corporate Affairs and Registrar of Companies. The object of the change made in section 55A and 621 of the 1956 Act is to provide that Securities Exchange Board of India to be entrusted with the powers with regard to all matters relating to public issues and transfer including power to prosecute defaulting companies and their directors. Section 24 of the Act came into force on 12/9/2013. It seeks to provide that issue and transfer of securities and non-payment of dividend by listed companies or those companies which intend to get their securities listed shall be administered by SEBI and in other cases shall be administered by the central government. SEBI has no jurisdiction over companies which are not listed and which have not even applied to a stock exchange. The main feature of the new Act is the excessive delegation to the executive. Out of 470 sections, more than 300 sections use the words as may be prescribed. This indicates that the essential legislative function have now been delegated to the executive and these can be altered by mere notification. The provisions of the new Act clearly pave the way for better corporate governance and protection of the interests of the shareholders and other stakeholders. Dear viewers, I hope you enjoyed this session. Thank you one and all.